Let me begin by welcoming and thanking Professor Anne Orford from Melbourne University, who is here with us now for the second day. Some of us already had the pleasure of spending some time with Anne yesterday in a smaller set workshop, and she has very much enriched our intellectual life very much. And so it's great that we will hear from her today in this lecture on how to do things with climate reparations. Before I give the floor to Anne, let me introduce her properly and give you really like the impressive CV that Anne brings with her, because it's truly wonderful that she came here. As mentioned, Anne is a Melbourne Laureate professor and the Michael D. Kirby Chair of International Law at Melbourne Law School, and a visiting professor of law and John Harvey Gregory Lecturer on World Organization at Harvard Law School. She researches and teaches in the areas of international law, international dispute settlement, international economic law, climate change, and the history and theory of international law. She is a member of the Permanent Court of Arbitration, a fellow of the Academy of Social Science in Australia, and a past president of the Australian and New Zealand Society of International Law. She has been a visiting legal fellow at the Australian Department of Foreign Affairs and Trade, and an international expert advisor on climate change and international law to the Pacific Islands Forum. Our fortunate occasion here is that Professor Orford has been appointed by the Swedish Research Council as the Olof Palme Visiting Professor at Stockholm University in this year to conduct a project on the securitization of climate change. In addition to visiting Harvard Law School since 2019, she has been a visiting professor of law at Université Paris 1, Panthéon-Sorbonne, at Hedda Anderson Visiting Chair at Lund University, the Raoul Wallenberg Visiting Chair in Human Rights and Humanitarian Law at the Wallenberg Institute, and Visiting Professor at the University of Gothenburg, and finally, Emile Noel Research Fellow at NYU Law School. She also presented a special course in the Hague Academy of International Law, just around the corner here from us, in 2021. She has published extensively, most importantly, maybe to mention the books. The latest book on international law and the politics of history, published by Cambridge University Press, was awarded the 2022 European Society of International Law Monograph Prize for Excellence in International Law Scholarship. And she has a number of other books. I think one of the most famous ones and most influential for me is the book International Authority and the Responsibility to Protect, also published by Cambridge University Press. She has been awarded honorary doctorates in law by Lund University, the University of Gothenburg, and the University of Helsinki, the Woodward Medal for Excellence in Humanities and Social Sciences by the University of Melbourne, and 3 Australian Research Council fellowships, including the Kathleen Fitzpatrick Australian Laureate Fellowship. And it is particularly nice to land on the Laureate Fellowship, a 5-year research program that Anne undertook on civil war intervention and the transformation of international law, as this was also the opportunity for me to get to meet Anne for the first time as a first-year PhD candidate at the University of Melbourne. Anne had assembled a stellar group of scholars and as PhDs and postdocs, and always very generously invited me to participate in the discussions, the workshops, the conferences, the dinners, and everything that came with it. And so those years really opened the world of scholarship in international law to me. So thank you very much, Anne. It's a pleasure to have you here. It's a great honor. The floor is yours.
Well, Andrea, many thanks for that very warm introduction. It's such a pleasure to have been here for the past few days already. I've been very lucky to have been able to talk to some of the early career researchers here about their enormously interesting research. Now it's my turn to step up and try and make a coherent argument after talking to them about theirs. So this talk today, as you've seen, is on the topic of how to do things with climate reparations, and it draws on a article that's forthcoming in a special issue of the American Journal of International Law. It's an invited contribution to what will be a special issue both in the journal and in ACIL Unbound on reparations. Including colonial and climate reparations. So I'm one amongst a number of people who are making a contribution to that special issue. And here I wanted to explore, in particular, the involvement of international lawyers in developing responses to climate change through focusing on this question of reparations. Now that role of international lawyers has been deeply contested, and the debate over whether and when climate reparations should be paid for loss and damage has been a central part of this contest and struggle over the role of international law in responding to climate change. And that push for climate reparations has been fueled by decades of attempts to have loss and damage caused by climate change treated with the same seriousness as we would treat issues of reparations for damage caused by war and conflict, or indeed reparations owed by a state for injuries to foreign investors. So that debate over reparations for the injuries caused by climate change is part of a much broader struggle over the nature of the global political economy and the realization of distributive justice in and through international law. And that struggle raises much broader questions about what reparations are for in international law more broadly, particularly when we're thinking about something like climate change. And my argument here is at stake is a broader question that goes indeed to the heart of the current global political economy, and that is the question of who should bear the social cost of industrialization on a global scale. So I use that language of social cost for a reason. I'll come back to that in a moment. But focusing on this question of social cost is partly a way of talking about climate change as part of a much broader picture. Often when we hear discussions about how international law deals with loss and damage, we'll be hearing those discussions over the next week or so in the context of the current COP meeting. We seem to think of it as a problem of inaction. So we haven't yet seen international law step up and manage to put in place a regime to address loss and damage as part of the negotiations under the UN Framework Convention on Climate Change. So there the problem would seem to be one of a failure of international law to intervene and to act in the political economy, a failure to redistribute the costs of climate change. But I want to argue here that the focus on this need for international law to develop a regime, the argument that it should do so, ignores the fact that in fact international law has already developed such a regime. It has developed that regime through the background rules governing what states can do with their territory. And indeed, international law has been laser focused on this question of allocating the costs and benefits flowing from industrialization and technological innovation for decades. Here we're going to be focusing particularly on the question of cost, but of course international law is also central to allocating the benefits of industrialization and innovation. But in the mid-20th century, this question of damage really appeared on the international agenda, because of the many ways in which industrialization began to intensify and spill over boundaries. So, for instance, we saw disputes relating to transboundary air and water pollution from large smelters. We could think of the Trail Smelter arbitration, for those of you who are international lawyers, an iconic arbitration from the 1930s, dealing really very much with a very similar kind of question of pollution across borders resulting from a large smelter. We saw the fallout from nuclear tests and nuclear accidents becoming a question. We saw the issue of dumping of wastes. We saw the issues related to falling space objects and the hazards accompanying new forms of offshore mining and drilling, as, for instance, the continental shelf began to be opened up to oil and gas drilling. And since that time, I want to argue that international legal debates over issues of state responsibility and reparations have been central to the process through which social costs and benefits of technological developments have been allocated globally. And the result, I want to suggest, is an unjust increasingly unjust distribution of this increasingly transboundary cost of industrialization. So understanding how that's happened isn't straightforward because international law doesn't have an international legislature to which we can point. There's no central authority through which decisions about questions of allocating cost are made. So instead, we have to look at multiple sites at which law shapes the distribution of climate-related loss and damage, and it won't always do so specifically in that language. But these many small decisions add up to a regime that does address this question of loss and damage. And so here I want to move this process of lawmaking that goes on in the background to the foreground of my analysis. I want to focus on the ways in which states have debated and international experts have debated issues that collectively contribute to allocating the social costs of industrialization, including those related to climate-related loss and damage. And so the core argument I want to make is that this has happened by producing a sense of inevitability or necessity about a particular, and I'm going to stress, contested account of the background rules that govern climate reparations. So international legal arguments play a central role in making it seem kind of inevitable that certain forms of reparation are obviously legitimate and a normal part of business as usual, reparations to investors, reparations in the context of conflict, for instance, and that others appear impossible or illegitimate. And that is the argument we sometimes hear made about climate reparations. The suggestion being that it's somehow unusual, there's something kind of strange about expecting some kind of payment for historical damage, as if that wasn't what law does all the time. Or there's something unusual about asking a state to be responsible for harm it caused in the past, whereas that's something that happens all the time. So I want to kind of resituate this debate over reparations back right in the center of international law and think about how strange it is that we would treat the UNFCCC regime as the only place that deals with climate reparations. Now, I'm going to stress this point as we go through, because we're now seeing this issue being dealt with increasingly by international courts and tribunals for the first time in history. States have tried very hard to keep this question out of courts and tribunals. And we're increasingly seeing in the written submissions of major emitters, like, I should add, my home state, Australia, the argument made that it's only within the UNFCCC that these issues are dealt with, that the broader issue, that the broader law on responsibility, liability, human rights, marine pollution, that doesn't have anything to do with climate emissions. That's all just dealt with through a special regime at the UNFCCC. So I want to say we're going to spend the next half hour looking at 6 decades of argumentation, and I can find nowhere at which any state has agreed to the proposition that the UNFCCC is designed to contain the meaning of emissions, of responsibility for emissions, or indeed to create a more permissive regime at which states can do more damage through climate emissions than they can do through anything else. So there's the take-home point, and that's where it kind of lands again at the end, so you can all relax now, and I'll try and, as the young people say, show you the receipts for that argument. I hope the intervention then does 3 things. The first is to focus on these background rules relating to loss and damage, and in particular to what states can do with their territory. So I want to suggest that if we attend to these background rules, we won't be looking for government intervention in the form of, say, taxing emitters or in the form of redistributing through climate finance to resolve the problem. We won't be looking for redistribution. Instead, we're going to be thinking about distribution. How does the law distribute the entitlement to cause harm by using your property? So that's the first move. The second way I want to kind of unsettle the current narrative is to suggest, as I've already done, that the debate over climate reparations isn't marginal, isn't illegitimate, isn't somehow something that we wouldn't anticipate being dealt with in international law. It's absolutely the central business of international law to deal with issues related to harm caused by use of a state's territory. And third, I want to suggest that the idea that we kind of repeatedly hear suggested in debates around climate reparations is that somehow freedom is a very one-sided affair. And a nice example is, of course, the famous quote by George Bush at the Rio Summit in 1992 that the American lifestyle is not negotiable. The American lifestyle is not up for negotiation. If it wasn't then, it certainly isn't this year, I think. But in any case, the idea that a state has a non-negotiable right to use its territory in ways that cause harm beyond its borders treats freedom or liberty as somehow unilateral rather than relational or reciprocal. But the unconstrained right to allow one's property or territory to be used in ways that cause unlimited harm to other property owners without any resulting liability would mean that property and territory have no meaning. The right to do whatever you want and destroy another person's property means there is no property. We'll come back to that in a minute. So as I'll suggest, the approach that's being proposed here doesn't conform to even the most libertarian philosophies of property or theories of risk, or at least the most libertarian ones I can imagine, but who knows where we're headed. So powerful states and high-emitting actors have been able to leave their theory of risk untested by pushing to keep the question of climate-related obligations out of international courts and tribunals, largely by insisting that interstate negotiations are the right place to resolve such a complex problem. But like a powerful state dragging out peace negotiations while they're winning a war, this slow walking of negotiations has allowed business as usual to continue by avoiding any discussion of the principles at stake. And I think we're at a turning point here. And as a result, we are seeing powerful emitters saying the quiet part out loud. That is saying that they have, through the UNFCCC negotiations, created a specialised regime which allows them to cause more harm through greenhouse gas emissions than they would otherwise be entitled to cause under general international law. That's how I read some of the submissions before the International Tribunal on the Law of the Sea. That's how I read some of the submissions in human rights cases. And from what people have told me from who are representing states in the climate advisory that we're about to hear at the ICJ, that's also what states are arguing there. We'll find that out on December the 2nd. Okay, so this talk then aims to challenge that current interpretation, as does the broader article on which it draws. I study debates that have taken place since the 1940s over the obligations that states owe to protect foreign persons and property, both within and outside their territory. Those debates have taken place at the International Law Commission, or the ILC, as part of two work projects addressing state responsibility, very well known at this law school, and liability for transboundary harm. They've taken place at the UNFCCC negotiations and during investor-state disputes over losses caused by environmental and climate regulations. And I want to suggest that we can understand debates taking place at each of those sites in terms of an overarching struggle to allocate the costs, the social cost of industrialisation on a global scale. So for the remainder of the talk, this is how I'm going to proceed. First, I want to say a little bit about why background rules, why I'm focusing on background rules here through the idea of social cost. And then I'm going to talk about 5 different ways to do things, picking up the theme of how to do things with climate reparations. The first, how to avoid the decolonisation of state responsibility. There I'll look at negotiations on the draft articles on state responsibility. Second, how to avoid strict liability for transboundary pollution. I'll look at negotiations or drafting of ILC principles on transboundary harm. Third, I'll talk about how to avoid strict liability for the harms caused by climate change. There, I'll talk about the UNFCCC negotiations. Fourth, I'll talk about how to make states pay the polluters. There, we're going to look at ISDS. And finally, I'll talk about how to save the planet by reallocating the social cost of climate change, which is what I hope we're going to see. So before we go any further, let me talk a little about the first point, why background rules. And here I'm going to just refer to an article, an intervention made by Ronald Coase in 1960 in his article, The Problem of Social Cost, which is probably familiar to many of you. And it became a key impetus both for developments in economics and for critical legal studies. I will be drawing rather more on the critical legal studies take on it, but I'll mention a little about both. And so here, Poes was very much concerned with the kinds of situations that arise in the context of climate change. So here, he in fact begins with a key example of a factory causing harm, causing pollution to a neighbouring property through causing harm through polluting the air. And he was there drawing on, referring to centuries of disputes in which this kind of issue had arisen. Disputes that concern the destructive effects of industrialisation, both on workers and on neighbouring properties, properties that were neighbouring the new railways, the new factories, and so on. And there'd been this kind of century of judges domestically, legislatures and legal reformers that had experimented with numerous ways of responding to the resulting disputes to which this new kind of industrialisation was giving rise domestically. And these responses in the law had taken a number of forms. So we saw, for instance, legislation to prohibit harmful activity, legislation to regulate or zone harmful activity, so you wouldn't have the factory beside the farm, social insurance or tax mechanisms to redistribute loss amongst members of a hazardous industry and to ensure the protection of victims, strict liability regimes to govern dangerous injuries, or fault-based laws of negligence. What we don't see in that list is, oh, well, that's too bad. So what we don't see is you can just harm the neighbourhood. That is not a position that held anywhere in the industrialised world as these kinds of disputes played out. So there are a lot of criticisms of the ways that municipal law dealt with this in industrialised states. And the kind of general argument would be if you establish even a polluter pays regime with a strict liability regime, that means you can compensate people who are harmed by industrialisation, that nonetheless justifies the degradation of the environment by industrial capitalism, because you just pay off the victims and you can continue to rapidly industrialise. So the critique of even the most strong regime of a strict reliability regime, whether or not you're at fault, you still have to compensate the people you've harmed. The critique of even such a regime is it justifies, accompanies and justifies the environmental destruction caused by industrialisation. But at least those who are injured have a right to compensation, even under the most permissive regime. So economists had also kind of picked up on these debates, and in particular, economists were very influenced by Arthur Pigou and a book called The Economics of Welfare, which had expressed concern about what we would now refer to as externalities, the facts that social costs of industrialisation caused to third parties or people who weren't directly concerned were too often not included in the social cost, in the total cost of a product. Thank you. Exactly. That's great. I see a television's been wheeled out. That's very well. So governments, according to these kind of economists, the argument was that governments should intervene in the context of a market failure to ensure that the social costs to third parties were included in the cost of a product. Coase was really worried that economists had got too excited about this, and he thought that government intervention wasn't necessarily a great thing. And he has three things in his argument that I think are interesting for us. The first is to say the problem is reciprocal. So Coase said, I don't love it that we're just talking about the cost to the farm in that situation. In the example that I gave, in opening up a factory that's polluting beside a farm, that there's a potential cost borne by both of those parties. On the one hand, there's the cost borne to the factory if it has to stop polluting because this farm wants to hang around, or there's the cost caused to the farm if the factory keeps polluting. One is a financial cost, one is a material cost. He treats them as the same. We might want to disagree about that, but he says we should think of the problem as reciprocal. So the cost will have to land somewhere. And the question of who should bear the cost, he says, is a question of efficiency, and it should be based on how we maximise value. Okay, we could have a very long discussion, we have another whole hour or so on how we think about value and valuation. we all understand it's a potentially normative rather than technical process. We'll come back to that. But at the very least, he says we should think about this as a reciprocal problem. Secondly, it's not only going to be through government intervention that cost is allocated. It won't only happen through taxing or prohibiting or polluting or zoning or insurance. Costs will also be allocated through the background rules, that is property, contract and torts, that govern what you can do with your property. So even before the government intervenes, there will be an allocation of costs depending on how the courts have set up the rules governing property. So in our case, thinking about climate change, that means the rules governing territory. What can you do with your territory? Even before you negotiate, for example, at the UNFCCC, over specific perhaps forms of financing or taxing, you will already have allocated the social costs of industrialization, of carbon-fueled industrialization, through the background rules governing what you can do with your territory. And he makes the point that the right to do something that has a harmful effect, emitting greenhouse gas emissions, is also a factor of production. So we should think of it as a form of comparative advantage if the factor of production allows you to cause harm. Third point, government intervention in such contexts isn't always efficient. Not always, I've italicized it because it's so important. He doesn't say government intervention is never efficient, but he says it depends on the situation. And if you happen to have a situation where there's no cost to transact the transaction, where you know all the parties involved, whether you can communicate with them efficiently, and you can properly determine everyone's rights beforehand, then it may be the most efficient way to deal with a situation where you have to allocate social cost is to bargain. But there's a lot of maybes. And what I've added as my own addition is that parties also have to have the capacity to relocate. Because in his model, you might buy off the farmer, but they have to be able to take the money and go somewhere else. You can't just destroy their property and leave them sitting there with nothing and give them a little cash. That's not going to work. So of course, relocation has to be part of the story. Okay. So law and economics says scholars based in the US run with that idea, that third point. Government intervention isn't always efficient. Markets are the best way to allocate social cost. We can trace that all the way through through the debates around the UNFCCC, through the influence of Coase and some people that he influenced, who get picked up by William Nordhaus, who shaped the US position at Kyoto, on and on and on. I'm not really going to talk about that today. I want to talk about what critical legal studies did with the argument, which is to say, let's pick up two of the points that he makes. One is that the allocation of social costs takes place through background rules, and second, that we might then redistribute social cost through reworking those background rules rather than government intervention. So in our case, we apply that to international law. We're thinking about clarifying the rules that govern territory rather than negotiating a whole new regime through the UNFCCC. Okay, so now we have a gallop through 5 different sites at which states have attempted to do this. And what I want to do here is downplay the significance of the UNFCCC and think about all of the other ways in which these background rules have been negotiated. So because states bargain and activists campaign in the shadow of these background rules that distribute costs and benefits. So even if we think the right way to address something, a complex problem like climate, is politically, we will still always be negotiating or bargaining in the shadow of the law, that famous idea. And so any attempt to demand a fairer or juster or more efficient allocation of risks will still be structured by these background rules. Okay, so how did we avoid seeing this addressed through the negotiation or the drafting of articles on state responsibility? So I want to argue that a number of things happened here. The first is the carving off of the rethinking of substantive obligations relating to what a state can do with its territory. So I've looked through many reports on the background of the drafting of these state responsibility articles. I know that Andre's team did much of that, has spent a decade doing this work. Catherine Greenman, one of the students, PhD students from here, who also joined us in Melbourne, has written a wonderful book on this. So has Svi Nissal, and in a crossover episode, Svi Nissal has reviewed Catherine's book, which is also worth reading in the European Journal. And basically the point to note here is that one of the issues at stake in these state responsibility negotiations was what should the law governing the protection of property of aliens, or we would now say foreign investors within a territory, become in the age of decolonisation. It had mainly drawn on Latin American mixed commissions that came out of the decolonisation of Latin America, and it had very much privileged the rights of Western investors. So there was a very robust argument about the need to clarify what states can do on their territory to the property of foreign investors. There was a related, and I think much less discussed, debate over the liability for transboundary harm that emerged specifically because of the context of nuclear testing that had begun in the Marshall Islands, where the US had tested over 60 nuclear weapons, including their famous Castle Bravo tests that caused enormous damage. And so a number of members of the tribunal of the ILC also argued that you couldn't talk about responsibility for harm done to foreign property on your territory if you didn't also talk about harm caused to foreign property outside your territory. You had to think about those two things together. And if we think about them, one has a colonial structure and the other doesn't. Indeed, they both have a colonial structure, but in a different way. Harming foreign investors, well, preventing harm to foreign investors, is a very colonial move, and harming everyone else through your industrialization is also a very colonial move. So members from India, from Mexico, Tonkin from the USSR all said we have to think about these things together. It was so disputed that the result was we won't think about substantive obligations at all. So all the substantive obligations were put to one side. Instead, we'll only talk about secondary obligations. So that is the obligations that arrive after those first set of obligations have been discussed, including reparations. And again, I'm cutting this story obviously very short. Decades of disputes over whether there should be full reparation for loss and damage, decades of dispute over whether there should be any provision ensuring compensation doesn't deprive a population of its capacity to its own means of subsistence, ends up with a commitment to states have to provide full reparation for loss and damage caused by an internationally wrongful act. So I think that's the worst of all possible worlds when it comes to decolonisation and for addressing how we think about harm. Powerful states didn't ever put this to a negotiated treaty, so it's just attached to a General Assembly resolution. But the provisions on reparations begin to shape how we think about reparations in the context of investment law. What we don't ever see is a clarification of substantive law relating to either the treatment of investors or transboundary harm. So an aura of generalisability makes the provisions on full reparation appear much more legitimate, but we don't get any development of these background rules. So much is then going to turn on where those background rules are developed. And that's the last three sites that I mentioned. The ILC then turns to discuss that through another work program on transboundary harm. The UNFCCC then becomes a venue for discussing that in relation to climate, and ISDS, Investor-State Dispute Settlement, becomes a venue at which we see a far more elaborate regime for repairing investors than we would ever have seen, I think, if it had continued to be negotiated through the ILC. So let me just touch briefly on each of those. If we then turn to think about what happened at the ILC in relation to transboundary harm, this issue didn't go away just because it was carved off from the state responsibility negotiations. In particular, that was because transboundary harm didn't go away. It was becoming a more and more significant issue as we began to see industrialisation expanding and intensifying. So in particular, we see nuclear tests becoming an increasing issue. We see the peaceful use of nuclear energy as a problem. For instance, if we think about the Chernobyl explosion, we see the beginning of oil and gas exploration on continental shelves that had just been claimed. We saw acid rain emerge as a question in Europe, and we see the problem related to space junk potentially falling out of the sky. The US and the USSR both arguing they could send their space vehicles anywhere, as well as later the ozone layer and greenhouse gas emissions. We also saw a debate emerging amongst legal scholars about these new problems arising, transnational problems arising due to modern science in injury, and an argument that as a result, we needed a strict liability regime. So the debate that emerges at the ILC is not, does international law say anything about transboundary harm? Everyone assumed, explicitly, it's spelled out over and over again, that we all agreed that a fault-based or negligence model applies in international law. But rather, the question they asked was, should there be strict liability for transboundary harm for dangerous activities? Robert Quentin Baxter from New Zealand was the first special rapporteur on this point, and he says, no one challenges the authority of the great undifferentiated principle that it's wrongful to cause harm to other states. He refers, for instance, to Trail Smelter and Corfu Channel, two early judgments, an arbitration and an early judgment of the ILC, which had made clear that there was a principle that states have an obligation not to knowingly allow their territory to be used for actions contrary to the rights of other states. It's also worth remembering that in all of those cases, the legal advisors of the US, in the case of Trail Smelter, the UK, in the case of Corfu Channel, and Australia, in the case of nuclear tests, all say clearly there is, at a minimum, a fault-based standard that applies in international law. And I'm going to have to jump over that. But we can see that even Cordell Hull, famous Secretary of State for the US, says the United States is entitled to insist that an agency without its borders shall desist from polluting the air within the territory. That principle is repeated in the Stockholm Declaration of 1972, and numerous states, including Australia, propose a strict liability standard as late as 1972. And we can see that at the very least, we see negligence-based standard there in Principle 21. States have a responsibility to ensure activities within their jurisdiction don't cause damage to the environment of other states or areas beyond their jurisdiction. This is pretty clear. We're just working with a fault-based model here. Again, in the case against France, Australia puts forward quite a strong argument in terms of nuclear testing that simply having radioactive fallout in our territory was a violation of sovereignty. Didn't have to prove damage. Just having fallout in your territory violates your sovereignty because Australia has a right to determine what acts will take place within its territory. And New Zealand said the same thing. We have a right to decide how much radioactivity our citizens are exposed to. We have all sorts of regimes in place to do that. You can't just dump radioactive waste on our territory. So the legal injury is the interference with sovereignty. So the question facing the ILC, and Quentin Baxter was in fact a member of the New Zealand team in those cases against France, was simply whether there should be a new, stricter regime, not whether there should be any regime. There was a regime, fault-based, just whether there should be a stricter regime. He said until the 20th century, states had been able to act as if they could do whatever they wanted on their territory and not have to worry about whether they'd be harmed. But he said that was no longer possible because of the growth of technology. So states had been able to pretend there wasn't a problem, but clearly states can't do whatever they want if it's going to harm another territory. And he thought Trail Smelter was the right response, that you would have, you wouldn't ban states from innovating and having new technology, but they had to pay for any damage it caused. Okay. We might then have expected that states would step up in the aftermath of that and begin to negotiate new and stricter obligations concerning state responsibility and liability. And we did see that in many issue areas. So we saw new liability regimes in relation to nuclear liability, acid rain, ozone depleting substances, oil pollution, space objects. In each case, you're getting a stronger, stricter standard of liability. And the expectation was that's what we would see with the UNFCCC. So I think it's very important to understand the UNFCCC in these terms. It's a regime to create a stricter liability for a dangerous substance in the way we'd seen happen over and over again. And it was, I think, kind of to be expected that that's what would happen. But of course, as highly emitting states begin to realize what the stakes are here, and also as the lobbyists in the fossil fuel companies become more and more entangled with states, we begin to see an extraordinary dragging of heels about this. So we do see states agree that the aim of the UNFCCC is to stabilise greenhouse gas emissions in the atmosphere at a level that would prevent dangerous anthropogenic climate change, but we really don't see all that much more. No new stricter obligations of conduct, limited enforcement put in place, and reluctance to address loss and damage, particularly in the language of reparations. In contrast, the other aspect of the law on state responsibility that members of the ILC had to be addressed at the same time, alongside transboundary harm, you had to rethink these obligations related to investors. Exactly the opposite happened. Here we find that we've seen an increasingly clear articulation of broad obligations on states to protect investors, and we have seen increasing forms of enforceability of those awards. We've also seen the wholesale adoption of the notion of full reparation from the draft articles on state responsibility. As Steve Ratner says, it's become a mantra. So where once, before the draft articles, states would try and balance the interests of home states and host states when it came to awarding compensation, now they've gone full throttle on full reparations, referring to the draft articles, and as Martins Paparenskis has said, giving rise now to a real concern about crippling compensation. In the context of climate change, that is a significant problem because there are more than 2,500 bilateral and multilateral investment treaties, many of which offer protection to fossil fuel investors. That's no accident, as Andrea has shown us, and Nicholas Perrone, fossil fuel investors or fossil fuel lawyers were deeply involved, non-entrepreneurs, in the early development of ISDS in the mid-20th century. So older investment treaties have very broad protections for investors. Most were negotiated before climate change was understood to be a pressing issue, so have very limited exceptions for the protection of foreign investment. And many measures required to decarbonise the economy will turn fossil fuel investments into stranded assets, the suggested global value of those assets being as high as US $17 trillion if fossil fuel companies have to leave all those assets in the ground. There's a significant risk that ISDS will be used to seek reparations for climate actions because fossil fuel investors have been major users of the system. Approximately 20% of all ISDS cases have related to fossil fuel investments. 100 of the most polluting fossil fuel investors, the carbon majors, are among the most litigious companies using ISDS, initiating among those companies 33% of all known fossil fuel arbitrations. The majority of them have been decided in favour of investors, and although we've only seen a small number of claims specifically related to climate action, there are now an increasing number of cases emerging, and if you look online, you will just see brazenly law firms now saying you should think about where you locate, how you structure your company so you can make use of ISDS if you're a fossil fuel investor. There's nothing, of course, to stop investment arbitration tribunals behaving properly and thinking more carefully about how the social cost of carbon should be allocated and saying that the risk shouldn't just be borne by states, but that's not what we're seeing to date. And significantly, for my point here, if we're worried about the just allocation of loss and damage, nearly 70% of treaty-protected oil and gas projects at risk of becoming stranded are in the global south, while the investors are in the global north. So that means states that have not been responsible for climate change are now most likely to be the states paying reparations, but they're not going to be paying them to small island states that are going underwater. No, they're going to be paying them to fossil fuel investors from the global north. I cannot think of a legal theory that would justify that, a moral theory, a political theory, as I say, even in my most libertarian nightmare fantasy. Cannot imagine how you would explain that. So, how did we get here and how might we get out of here? So states have maintained tight control over the way that we think about this area of law. They've really tried to keep these questions out of the hands of courts and tribunals. So we haven't really been able to see what a principled accounting of these background rules would look like. And more recently, as I've said, major emitters have begun to argue that in any case, the standard of care related to the damage caused by greenhouse gas emissions is somehow not from the general law, but is specific to the UNFCCC. And that's been rejected by ITLOS, happily, in its advisory opinion on climate change. And I would be very surprised if it's not rejected by the ICJ, but we'll see. And the primary exception to this reluctance of states to have matters dealt with by courts and tribunals is, perversely, that they continue to allow these matters to be brought before investor-state dispute settlement mechanisms. But I think it's a mistake to overstate the extent to which states have been able to shape international law to their own ends. It's important to resist the idea that the sense that these arguments are designed to produce that somehow, somewhere, magically, I can't find where, states somehow agreed to a new regime of liability for loss and damage. That never happened. So I have now been, I had a 70,000 word paper to start with, so you'll be pleased to hear I'm not presenting all of it. There is nowhere in which states have agreed to this proposition that there is a new regime of liability that relates to loss and damage. It's a perverse argument that that's why states sat down together to negotiate under the UNFCCC regime, that somehow they wanted to have more damage from carbon emissions rather than less. Remarkable proposition in my view. So no states have states agreed to that. And the background rules governing responsibility and liability have been settled since Corfu Channel. Corfu Channel has been relied upon by the ICJ over and over again as the harm prevention rule. It's been relied upon by ITLOS. It's never been reconsidered. It's never been overruled. And it's never been argued that it should be overruled. So those background rules have been settled since the 1940s. And so to return to COES, these background rules really matter because we might, as I said, prefer negotiating or bargaining, but bargaining takes place in the shadow of the law and in the shadow of these background entitlements. So it's not that states have to negotiate a fault-based mechanism for dealing with climate change. That is the background rules of responsibility and liability. They're already there. They might have to negotiate a stricter liability regime. I'd be happy to see it. I think there's a good argument for it. But the argument that the background rules have somehow stopped applying, I think, can't be supported. And the lack of clarity about background rules has really helped major emitters. That's been able to be maintained because we haven't seen these issues appear before courts and tribunals. So I think in that context, what we're seeing at the ILC, which is now taking up of these issues again through new work programs on compensation and on due diligence, growing calls for reform of ISDS and the new term to international courts and tribunals is a very valuable opportunity to think again about this social cost of industrialisation. And rather than worry about this as a misplaced faith in judicialisation, I think it's a chance to rethink this frame.